Hey guys, so this is chapter 1, first set, part 2. I got interrupted. I apologize on the other video. So we'll just finish up talking about defendant, and then we'll finish up our words here. Shouldn't be too long. So we were talking about when a person goes from being a suspect to being a defendant. And your textbook is very clear that it's when charges are actually filed against a person. That is when they become a defendant. So that legal action, they give you a couple examples here of a warrant being issued or an indictment being found, or, any other kinds of charging documents would make that person a defendant. Okay, so your next word is initial appearance. So initial is like first. Appearance is to show up, your first show up. It's a pre-trial stage in which a defendant is brought before a lower court to be given notice of the charges and advised of his or her constitutional rights. So, and I get into, sorry about that. I get into a lot more of these court appearances when we get into our courts and law unit, so I don't want to go too far into it. But basically, what happens, what's the next thing that happens after you get arrested? You have to be arraigned, right? You're brought in front of a judge and it's that arraignment is an initial appearance. It's your first appearance in court. And it's usually within, a few hours of your arrest, where you're brought in front of the judge and the judge clearly explains to you what the charges are that have been filed against you and tells you what your rights are, your constitutional rights. And this is where you would say guilty or not guilty, and almost everybody always says not guilty. So this is not trial. You're not going to trial. It's not a jury trial. The reason it talks about the lower court, and we haven't discussed this yet, but misdemeanors are heard and handled in lower courts, lower local courts. So city court, town court, village court. Felonies are heard in a higher court. So county court is a higher court. So if you were arrested, just really any kind of a charge, but let's just say it's a felony, out in the town of Brunswick, you would be brought to the lower court, which is the Brunswick Town Court, to have your initial appearance, to have your arraignment. And you may go to a different court, a higher court, the county court, if you actually go all the way to trial. But we'll get into that a whole lot more in courts and law. So it's just initial appearance, pre-trial stage. You're told what the charges are exactly against you, and you're told of what your rights are. Like you have the right to an attorney. If you can't afford one will be appointed to you. That's when that happens. Our next term is summary trial. And it is an immediate trial without a jury. So you don't always get or have to have a jury trial. Traffic offenses happen usually with a summary trial, and a lot of misdemeanors happen with a summary trial as well. And that would be just an immediate trial in front of a judge, and the judge decides guilty or innocent right then and there. And your very last term, this is the most important term that you will learn in criminal justice. And the term is probable cause. And there's a whole lot to talk about with this. We're going to talk about it nonstop for the next 2 years. But your textbook definition, which I think is not very helpful, is a standard of proof that requires evidence sufficient to make a reasonable person believe that more likely than not, the proposed action is justified. Well, let me just be very clear and very specific. What is the proposed action? It's either an arrest or it's a search. that's it. It's an arrest or it's a search. Both of those require probable cause in order to be legal. And we're going to get into this in notes and lecture a whole lot more. But a police officer needs probable cause to make an arrest, and he needs probable cause to conduct a search. And that probable cause is a pretty high level of proof. Doesn't mean 100%. It means a reasonable person would believe that given this set of circumstances and this set of information, that this person did do a crime, and or there are illegal items to be found in a particular place. And it's all the circumstances around that event, that crime, that point to somebody. So again, I don't want to go too far into it because this is just vocabulary review, but there's a whole lot to talk about. Probable cause is the highest standard of proof that we have for policing. We're not talking about courts. We're not talking about trial. We're not talking about beyond a reasonable doubt. We're talking about what do you need to make an arrest. Anything less than probable cause is going to be illegal. It's going to get thrown out because there wasn't enough, not enough proof, not enough evidence to make that arrest or conduct that search. And just quickly, a couple lower levels of proof that we're going to talk about is reasonable suspicion and a hunch, or I'm not thinking of the term right now, but those are lower than probable cause, and those are not enough. You have to get all the way up to probable cause to make your arrest or your search legal. And so, like I said, your book, just remember it's a standard of proof, okay? Highest standard of proof. It's the only one in the whole list here. Standard of proof, probable cause. All right, guys. So those are your 10 words for chapter 1, first set. I hope that this was helpful. Oh, and by the way, I didn't point this out. You have your little speaker here. I already read these to you, but if you want it reread to you, just play the speaker and it'll read you the definition. Okay.